Good morning to all of you. Welcome to Legal Matters by Sai Baba Sankara. In this video, we are going to discuss a beautiful judgment given by Honorable Justice D.V.S.S. Somayajulu of AP High Court at Amaravati regarding the reinstatement of a sub-inspector of police who was removed by the department in 2012. 11 ఏళ్ల తర్వాత ఆ ఎస్ఐ గారిని మరలా విధుల్లోకి తీసుకోమని చెప్పి గౌరవ హైకోర్టు వారు ఉత్తర్వులు ఇవ్వడం జరిగింది. ఎలా ఎందుకు అనేది నౌ లెట్ us go to the facts of the issue. The name of the SI is Mr. M.Vijaya Buaskar. He is from Nellore district. Actually, at the time of appointment, the allegation is that he did not give the correct information in filing the affidavit regarding the credentials. You may be knowing, they will be asking questions whether any FIR is registered against you, whether there are any cases pending against you, whether you are convicted in any case and things like that. Here what happened is, in the year 2004 or so, a case under section 34, maybe the case under Excise Act was registered against him, or he was figuring as an accused in a case of 34 Excise Act. Subsequently, in 2006, the case had ended in acquittal. Therefore, he did not mention that there are cases pending against him since the case has been disposed of. But after he joined the service, normally the people who are having grounds against him, they have obtained information through RTI, Right to Information Act, where it was disclosed that he was involved in particular case and he has ended in acquittal. Here, the government of Andhra Pradesh, or particularly the police department, they clearly stated that it is nothing but a suppression of the material facts. Here, all of you should know that the purpose of filing the affidavit, even in the time of elections, even at the time of appointment, at the time of recruitment, the purpose is to see the credentials, whether any cases are pending, whether any cases are disposed against him. That means to see how he will survive in the society, whether he is a fit man to be appointed as a police officer or not. That is the purpose. Even though the cases are pending against you, yes, definitely you can be allowed to continue the department, but not mentioning the fact. So in this connection, I request all of you to see my very recently previous video number 2479, where a judicial officer, lady judicial officer, she has also been terminated because she did not inform that she was the complainant in a case and in the counter case she was the accused person. There also the case, the police officer said that they are going to refer the case, but by the time of her appointment it was not referred, RCS number was not given. Ultimately she lost her job, right? So now you can argue on both these directions, on both these points. The government definitely vehemently argued. So actually now what happened is, this man, after the removal by the department, he approached the Andhra Pradesh Administrative Tribunal. APAT, they have stayed the orders of the government and they have asked the government to reinstate him. But normally government did not listen and they have filed a writ petition in the Honorable High Court of Andhra Pradesh, almost like an appeal. So that writ petition came before the Honorable Justice D.V.S.S. Somayajulu yesterday, and he has given the judgment just 2 days back, stating that after all it's a small matter, Excise Act. During that particular time, everybody, most of them are booked on Excise Act cases. Of course, it was not proved against him. It is a very simple issue. So, on behalf of Mr. Vijaya Buaskar, Sri Jada Sravan Kumar, High Court advocate and who is the founder of Mundadugu Praja Party, he argued that No doubt it's a very simple matter, and actually he has forgotten, since already the case has been ended in acquittal. He has forgotten about the issue, and this issue should not be made so much blowing or so that he could lose his job. After all, what is that? He is not involved in a case of moral turpitude. He is not involved in a murder case, not in a rape case, not in a dacoity case. After all, excise case. And the PP, he stated that no, Your Honor, if that is the suppression, he can suppress any other matter. Therefore, the government is rightly concluded that he has to be removed from the service. Ultimately, Honorable High Court stated that it is a very simple issue. Reinstate him. Take him back to duty. So, that man, I don't know whether the government will go to Supreme Court on this particular issue or not. But anyway, very good judgment. So, this is where the High Court shows its wisdom. Normally, I told you in 2479 video number, Supreme Court itself said that no, we are not going to give the job. Yet here, High Court is pleased to get him reinstated. Very good, important, bold and judicial decision. Please read the judgment and enrich your legal knowledge. Thank you very much.